The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This program had been created to educate, inform, and help you with the law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business. We continue to provide information and resources that'll help you determine whether you need or want to contact a lawyer. Perhaps we'll help you to determine that you can handle some issues yourself. If you do need additional professional counsel, they'll be better prepared, you'll be better prepared. Our goal, of course, either way, is to help you save time, money, and achieve the best possible results. We welcome and thank once again Attorney David Bazar from the Bazar and Associates Law Firm in East Providence for providing us the information and their insights each session. So today, personal injury law, with cases perhaps close to home, from opioid abuse to bicycle accidents to something called combo cases, questions that you may not have heard or heard answers to before. We'll provide some basic tips and information and things that you may want to consider as factors before you choose to pursue a court case and whatever happens after that. Let's begin, David, with a little recap of what is personal injury law.
So personal injury law is really usually a negligence claim that results in an injury to somebody. So it can result from someone driving negligently and injuring someone in an auto accident. It could be someone maintaining property negligently and creating a slip and fall risk where someone is injured as a result of that, or any other really type of injury that results from a situation where a duty is owed to someone and then that duty is breached. As a result of the breach, the causation leads to an injury that results in damages to the person. So medical malpractice theoretically is a personal injury case. Products liability could be a personal injury type of case.
Are these called tort?
Yeah.
All or some?
Negligence is a tort claim, which is a civil wrong. So it's one of many types of tort claims. Just quickly, since you raised it, there's an assault and battery, which can be an intentional tort. There can be defamation or slander, libel, that type of thing, which are torts. So torts are a civil wrong that is done to a person.
Okay, fair enough. Let's go through the steps and processes of what happens when someone has had perhaps a wrong. Not quite sure about whether or not it's a wrong, whether or not there's a case. How does that play out? What are the steps, David?
So first of all, in order for an attorney to consider bringing a claim for somebody, there has to be damages. And the type of case will determine how much damages is necessary for an attorney to be interested in the case. For example, in a malpractice case, if a doctor deviates from the standard of care and was negligent, and that deviation from the standard of care resulted in an injury, but not a significant injury, most attorneys would not probably take that case because of the expense and expertise required to pursue that type of case. And what I mean by expertise, you need an expert witness, which is very expensive.
So let's address that for a second. In preparing for this, I had come across an interesting issue, which was, they say that if you're thinking about having a law case and you need to discuss this with your lawyer, consider it carefully, because initiating a lawsuit certainly takes a long time and can be very costly. Costly for whom? Explain that process, David.
Well, most personal injury cases, lawyers will take those on a contingent fee basis. And a contingent fee means, and you see lawyers who advertise this, and I wouldn't go to a lawyer who advertises, by the way, just me, but it's no fee unless successful. You
Yes.
hear that quite often.
Yes.
And that is a contingent fee arrangement, which means that the lawyer has assessed your case, believes that the case is good enough for them to become involved in, worth their time and effort as well. And if for whatever reason the claim ends up without an award or a settlement or a judgment, then they don't charge you a fee. Sometimes they'll charge the cost to you, depending on the type of case. Sometimes they'll absorb the cost. But no fee unless successful is a contingent fee, usually depending on the type of case and the complexity. It can be a third typically, or as much as 40%, which you'll see in complex medical malpractice or products liability cases.
So actually, you're indicating that it could be costly for the person who is injured in some cases, but then costly for you in terms of your investment of time and everything else if it doesn't seem like it's a worthwhile case.
Right. That's correct. Most auto accident claims, for example, an attorney will take on a contingency, usually depending on the type of accident, a rear end or something like that, they'll even agree to pay the cost. So there's very little out-of-pocket risk to the person who was injured for bringing the case to an attorney. But that's usually because the attorneys assess the liability, and it's a clear liability. It's not a comparative negligence situation, or in Massachusetts, if you're more than 51% at fault, you won't collect anything. So they've made that determination that there's a good chance of recovery.
So when someone comes to you and you've evaluated it on the basis of its merits, you can't do it at face value. You have to do some digging first to figure out whether or not there's a legitimate claim. Do you have to invest some time yourself in all of these potential cases, David?
It depends on the type of claim, how much investigation you may have to do before you agree to take the case.
Okay.
For instance, if someone comes in who's in an accident, they bring the police report, you read the police report, you ask the client what happened, because the police report's not always 100% accurate.
Good point.
So you can usually make a determination on the spot as an attorney, having done so many of these, whether or not it's a claim that's worth pursuing. So you're looking at not only how the accident happened, who might be at fault, what witnesses you might be able to have to prove how the accident happened, but also what damages there are and whether or not those damages are worth your time and investment as an attorney into the case.
Okay. Before we get into some cases with detail, David, if you decide that you're going to take a case, how do you decide where the suit is going to be brought?
Well, hopefully, typically, when the case comes, it's a fairly new case, so it doesn't have to be brought for 3 years. Personal injury, the statute of limitations, in Rhode Island and Mass, at least as we're talking sitting here. Connecticut's 2 years, but I don't practice in Connecticut, so we'll stick to Rhode Island
Fair
and
enough.
Massachusetts. But in any event, the point is you usually hope you don't have to bring that case right away. So you would start by helping the client understand how the case works, telling them what you're going to do as part of preparation for the case. They're usually still seeing a doctor. You don't want to try to settle a personal injury case while the person's still treating, because that treatment pattern may change and you can't predict how someone's going to respond medically to whatever treatment they're getting. Every person's different. So you usually are working along with them, talking to them about what doctors they're treating with, what treatment they're getting, and what they are doing to make themselves better. And then when they're done treating, you start evaluating the case for settlement.
So how might that cause problems with what is referred to as the statute of limitations? If someone's undergoing treatment for who knows how long, is there a point past which you're up against that statute that says you've only got 3 more weeks or whatever to file?
Yeah, so if they're still treating and you haven't been able to settle the case, you do want to put the case into suit well in advance of the statute of limitations. So you would do that to protect the statute, even though they're not done treating, perhaps, because their injuries are so severe. But you would try to get reports to show what the prognosis is and what you might be able to expect, so that you can get yourself into a position to try to settle the case. But like you say, if you're 3 weeks out from the statute of limitations, you probably want to file the case to protect that statute.
And of course, this is clearly, I think it needs to be said, at the outset of the program, we say some things you can handle yourself. Clearly, when it comes to personal injury cases, not something someone can generally handle on their own.
Well, you certainly don't want to, and the reasons you don't want to are the expertise that's required in evaluating a case. Insurance companies aren't in business to compensate someone who's injured. They're in business to make money. So they're not going to offer someone representing themselves usually the fair value of a case. An attorney who's handled a lot of these types of cases knows how to evaluate a case, knows what goes into them, what you need to prove, and what evidence you have to gather to prove those things. And again, since it's a contingent fee, it's not going to cost you money out of pocket if you don't recover. So you're not in any worse position hiring an attorney, usually, if it's a good attorney, then you would be in much better position, I should say, than you would be handling it yourself.
Okay, so you did list the slips and falls in medical malpractice and personal injury like vehicles. Understanding that the _1 type of personal injury case is largely in the accidents involving cars, maybe it means motorcycles too at this point, sure.
Yeah.
Do you expect that there are going to be more of these now because even though it goes into a law June 1 in Rhode Island, no more texting and driving?
Yeah.
It should have always been illegal, but nevertheless, when people are getting into the situation where they are doing this and there's a bumper, fender bender, do you expect that there are going to be even more vehicle accidents that you're going to be handling? Is that likely to happen?
Well, there's always going to be motor vehicle accidents. And so texting actually had been illegal for some time. It's the actual even holding. The mobile device in your hand is totally banned to June 1st.
June 1st.
So as that works out, what you need to know is there are other reasons, always have been other reasons why people have accidents, not paying any attention, carelessness, whatever they are. So there are always going to be accidents. Hopefully, maybe less with people not holding things, mobile units in their hands while they're driving, but there will be accidents.
Is that ever going to be a defensible case if someone is arrested because they've had the handheld device, or if they're in a fender bender? Are you ever going to be in a situation where you're likely to be able to defend someone's doing this?
Well,
or is that just clearly a non-starter, a non-case?
Well, I think it's a matter of proof still. So what's the proof that someone had something in their hand? The police officer who gives the ticket is going to see that. And if it's an accident that happened afterwards, they probably didn't see that. You would be silly to admit fault at an accident, whether you're at fault or not. You can say, are you okay? Can I help you and stuff? But I wouldn't get out of the car and say, gosh, I'm really sorry. I had my phone in my hand and I rear-ended you. The police report's going to note that you rear-ended somebody anyway. You don't have to admit to it and why. So I don't think that that's going to be where people get pulled over and stopped because of an accident with a handheld device in their hands, but more so a police officer driving by, seeing someone doing it, and now can observe it and charge it on their observations.
Okay, so let's talk about vehicle accidents for a start. When someone is in an accident, if they are not bleeding, no trauma that's apparent, what's your advice as a reasonable person, then as an attorney? Should they not call you first, but go to the doctor, go to the hospital first, no matter what?
Well, a lot of people get into accidents where there's no obvious blood or injury like that, are so amped up because of the accident, they don't necessarily feel the pain right away. The adrenaline's rushing, they're worried about what happened, all of those things. So usually in that type of case, they'll go home and then something is going to start hurting. And once you start feeling pain, you should go seek help immediately.
So when someone has an accident, I know you've always said, take your cell phone if you can. Take your cell phone out, take the pictures of the car, the surroundings, the people who were there, et cetera, to help if there is a case, but also just because that's good proof and good documentation. When someone calls you and says, David, I have troubles, I hurt my back or whatever else, is that automatically a worthy case because they're already in treatment?
It's absolutely a worthwhile case for an attorney to start talking to someone about. Obviously, they want to look at all the issues directly and make a determination, but yes, an attorney will be more than interested in someone who calls up and says, I was in an accident, it was a rear ender, and I'm seeking treatment for my injuries. But the photo part, my generation, it's not second nature for us to think of our phones as cameras and take them out. But I can tell you there's been a number of cases that I've handled and I've been involved with where how did the accident happen? And then there's pictures from the scene. And I can think of one in particular where the client would have been pulling out of a parking lot to turn left. And the client's description is a car stopped one lane in each direction to let him out to turn left. And all of a sudden he's in an accident. Where did that other car come from? That car passed the stopped car and hit him. And so, not realizing exactly what happened, once he started thinking about, well, where did this car come from, what happened, took pictures which showed that he had already passed the other car that was stopped, was turning over the double yellow line, and the accident happened in the other lane in the direction that the car shouldn't have been traveling in. So that person was trying to claim, oh no, you pulled out in front of me. Well, no, I didn't. There was a car stopped, and here's the pictures that show the stopped car, our cars, at impact on the other side of the double yellow line. So, as they say, a picture can be worth 1,000 words.
And certainly that did make it very clear and
Right.
clear evidence for you. So if you take a case and it's a vehicle accident, usually people have insurance. Are they still supposed to call their insurance company immediately? And should they say, I've been speaking with my lawyer, or not?
Yeah, you should always call your insurance company right away. It's a requirement of your policy to cooperate with your insurance company and to put them on notice. So you put your insurance company on notice. If you are going to see an attorney, you should tell them who the attorney is and that you're going to see them, or if you've already seen them. But you should call the insurance company right away. So theoretically, you should have called before you even saw your attorney.
Good to know. Are most vehicle accidents settled out of court, David, or do most of them go to court?
Well, most of them do not go to trial.
Do not go to trial. Thank you.
But
Point of clarification.
many of
yes.
them will get a lawsuit filed, so it does go to court, quote unquote.
Yes.
But there are a number of ways along the way that they can settle. Arbitration, mediation, settlement conference, all types of different things that are available as we call ADR, alternative dispute resolutions, that will resolve a number of cases. The ones that usually go to trial either involve a lot of injury, where there's a dispute as to what's related to the accident and what's not, or a contested liability situation where there's a dispute as to how the accident happened. But there is ample opportunity, even after a lawsuit is filed, for a case to be resolved.
Okay, let's talk about, I understand workers' compensation. If you're hurt while working, there's some compensation for you. It's interesting as I read about this, and I think it's something that worth exploring. So if you are, can you still file, say, a personal injury suit while you are obviously in someone's employ and there's a workers' compensation issue right at the beginning of whatever happens? Usually workers' comp kicks in first, I would think, and then there's this thing called a combination case. Could you explain that?
Sure. We'll call it a third-party case.
A third party is what it is, yes. Okay,
So
go through
what
it.
happens, for example, let's say you work for a company, give me a job, CNA, okay? And you're traveling from one patient to the next, and you get rear-ended between jobs. Or actually, I can think of one that I actually remember more specifically than that. You're a CNA, but you go to somebody's house to take care of the patient, and there's a dog there that jumps out of the door, onto the street and bites you as you're walking in. It is a workers' compensation case because you're in the course of your employment. You're doing the work that your employer hired you to do. So you're correct, workers' compensation kicks in first. And workers' compensation will pay you for a number of things, but what they won't pay you for is pain and suffering. So depending on what state you're in, it'll give you a percentage of your wages, it'll cover your medical bills. If there's scarring from that dog bite in Rhode Island, you'll get compensated for that. If it's on your face or extremities in Massachusetts, you'd get compensated. But you don't get compensated for the full amount of your wages, the scarring in full as to what it might be worth at trial in a personal injury case, and the pain and suffering. So you're entitled to sue the person who is at fault, the tortfeasor, the person who owned the dog in that case, or if it was a rear-end accident on your way to your next job, the person who rear-ended you. What happens, though, you don't get double compensation you don't collect your workers' comp, and all of the value of your case on top of that. What you collect that is already been paid for by the workers' compensation carrier gets paid back to the workers' compensation carrier.
Good to know. And one of the examples that I had read about was the pizza guy. The pizza delivery person is hurt by another vehicle, and that negligent driver is the subject of the personal injury, even though workers' comp covers the pizza delivery boy because he was working for the pizza delivery company.
Yeah.
Interesting.
So the pizza delivery boy will have a number of interesting workers' compensation issues in terms of valuing what he's supposed to get, because he makes a salary based on his hourly wage, but probably tips as well. So his average weekly wage has to include both and make sure that's calculated out correctly. But he only gets a percentage of those wages, and of course the hot pizza fell on him and burned him, so he's got to get some money for the scarring that he had as a result of that, because there's a guarantee that the pizza will be hot when it gets there. And so the medical bills. So whatever the compensation carrier, workers' compensation carrier paid out, they get paid back. But there is some calculation, especially in Rhode Island, pretty easy to calculate, that pays back a percentage of the attorney's fee that the attorney gets in collecting on the third-party case, so that you're not paying the attorney's fee for the workers' compensation carrier to compensate them.
That's your combo case.
That's your combo case or third-party case.
So we've in the past talked about medical malpractice. Define it loosely before I go, or as you wish, before I address the opioid situation, which is new and important these days.
So I defined it actually quite specifically at the beginning. It's when a doctor deviates from the standard of care, and as a result of his negligence or deviation from the standard of care, he causes an injury to the patient.
So with those parameters, a doctor will typically offer his patient pain meds because he's in pain. Apparently that has become such an epidemic, as we've been reading about, hearing about. Now there's a potential for that doctor to be sued for medical malpractice. Would you care to
So it's an
comment on
interesting
that?
situation, and I would defer to the experts in that area because it's an evolving area. Many years ago, or maybe not so many years ago, drug companies who make the opioids would say they're safe, they're not addictive, and those types of things. So if you're a doctor prescribing that medication with that information, you have to assume that it's okay to prescribe, and that's what most of the doctors would have been doing when that was the case, and so you're probably not deviating from the standard of care. The question might be whether or not the drug manufacturers, which now could be a products liability case, were being accurate and truthful, and whether they could be sued for something along the lines of a tobacco case many years ago when they were making claims that, this doesn't cause cancer, it's not addictive, and that type of thing. So there could be class action suits involving those types of situations down the road. But the answer to your question today would be, it would seem that a doctor who is prescribing opioids willy-nilly without controls and 30 at a time, and here's another 30 and that type of thing, could be opening them up to a claim.
So as I read about this, when a doctor prescribes medicine to a patient without any valid medical reason or overprescribed it, I would think it would be very difficult to prove that there wasn't a need because the patient had pain. Many people can say that they had pain. Overprescribing, perhaps that's easier to document because there must be some standard. When you have your tooth pulled equals this many versus a leg amputated, it means something else. And then when they talk about there must be a follow-on of this case. So suppose the doctor didn't know prior to prescribing that the patient had been on other medications, is he liable then? Does that mean medical malpractice? Or if he had not only been taking other medications, how long had he been taking these and under what circumstances, and what else had been given as symptoms that there might be an addiction or a problem or a change of behavior? A doctor is now likely to be liable of medical malpractice for not monitoring changes of behavior. How can he possibly defend that?
That I'm not sure about. But I think it's really important for the doctor to get a history of what medications someone has taken, and if they've been on opioids with other injuries or still on them or whatever, to know exactly what they've taken, how long they've been taking it, and all of that information. And I would think that if a doctor takes that history, records the history, which is really important, and goes through it with the patient very carefully, they won't be liable if the patient lies to them, because you have to rely on the history given to you by the patient.
Sure.
There may be some other ways they could find out that I'm not aware of, but the example that you gave about overprescribing for too long a period of time, I think that's something that they have to really control, and that's something that I mentioned at the beginning, that, you know, it used to be, here, I'm going to give you 30 days worth, and I'll give you a renewal for, you know, another 30 days, and so forth and so on. You don't want to do that with opioids anymore now that you know the history of what's going on in that world.
And considering that if it does become a medical malpractice suit, if it didn't cause death, as we know it has with some other celebrities, but it certainly causes enough of a problem that now you're looking at the future of this person being in jeopardy. Maybe they lose self-esteem in the eyes of the family, but worse, they have an addiction problem that needs to be treated. You don't know how much it costs, how long. So all of those figures that are needing to be factored in or calculated, that seems to be something that's likely to be a very costly issue if it starts to escalate in terms of the number of cases that are arising.
It could be, and that's why physicians just need to be very careful. I think there's a place in the right dosage and amount for everything, you know, that is available to a doctor to help somebody. But they just have to be careful to know what they're doing, and to know the patient as well as they can, so that they are watching for problems and not creating problems.
It certainly seems that that is something that they're going to need to watch out for. And of course now naloxone, is that what it is? The Narcan shot. Narcan. If there weren't a doctor around to administer that, or a medic to oversee that, that case might be not just what the future of the patient's problems will be, but could have actually been a death-resulting issue. Is the doctor likely to be liable for that? It's interesting
Again,
question.
it depends on the whole history. If it's just one, you know, thing with the doctor that he did correctly, then probably not. But if it's an ongoing thing, then yes.
So many issues to cover. Thank you very much for tuning in to The Law Matters. We hope that these issues have been helpful to you. And please stay tuned to The Law Matters, because the law matters to you.